Yeah, this is Dr. Sami Chakravarti. Let me continue with the introduction to the Raghu Institute of Technology and today's program.
Yes.
Raghu Institute of Technology, Visakhapatnam, was established in the year 2007 with 4 departments under the able leadership of Chairman Sri Raghu Kalidindi, Vice Chairman Rahul Kalidindi. The college initially affiliated to Andhra University from 2007 to 2013, and from 2013 to 2018 affiliated to JNTU College of Engineering, JNTU UK, and was accredited by NAC with A grade for 5 years and NBA in the year 2016 and got autonomy from 2018 for 10 years. The college was re-accredited by NBA in the year 2021. The department ECE, CSE and MEC got recognized as research centers by JNTU KAPILA. The college is growing in a faster pace with its rich infrastructure collaborations with various industries and research organizations, having an exponential track of placements with the highest package of 34 lakhs per annum, MOUs with renowned organizations, good number of publications in Scopus, FPI, and WOS, etc. The college also having a strong student IEEE student ranks, PSI student chapter, IET student firm, IE Institute of Engineering student chapter, and many. These professional bodies organize plenty of academic, innovative, research-oriented, awareness, creative events. Nevertheless, the college is very active in its NCC, NSS, and Bharat Abhiyan programs, which shows its commitment towards the societal needs and awareness among the people around. We have Professor P. Satish Ram Chaudhary Garu, Vice Principal, HOD ECE as President, Institute Innovation Council, and also looking after several AICT initiatives like PLR, IIA, IIC, NISP, KAPILA, Parak, Karma, NEET, an opportunity to have a one-day awareness program on IPR and interaction with eminent personality like Mr. Ranadhir Kumar as a part of KAPILA scheme. Now I request my colleague, Mrs. T.L. Spandana, to introduce today's resource person, Ranadhir Kumar Garu. Madam, please take over. Thank you, Spandana Madam. Sir, over to you, sir.
Thank you so much, sir.
Yes.
Thank you, madam, for introducing in such a nice way. Just I'll ask all the participants, please mute yourself. Otherwise, I can mute from my side also. But if I'll mute you from my side, then we'll not able to unmute by yourself. So please mute yourself for the time being. And just when the first part of the webinar will be over, then you can ask your questions. You can write the questions from whatever questions you have in your mind. Otherwise, whatever questions will come when I'll explain the matters. So please mute yourself for the time being, and you can unmute when I'll ask you to ask some questions. Okay. So I welcome you all, the students and faculty members from Raghu Institute of Technology. It's indeed a pleasure for me to take this webinar for all of you, because we know that the innovations comes from the engineering graduates, and they are most interested in that. So I'll just tell you what are the intellectual property rights which can help you to convert your creativity into intellectual properties, and how to protect them, and how to get the economic benefit out of that. So Government of India is celebrating Azadi Ka Amrit Mahotsav, and in that context, Government of India has started a national awareness program, which was started in December 2022 under National Intellectual Property Awareness Mission. And now this program is conducted under Kalam and NIPAM. And Government of India has planned to reach the maximum number of students and faculty members up to 10 lakhs of students, so that they can be more interested to create the intellectual property, and they should be aware of fact that why it is important to protect that. So mainly the object of this awareness program is to spread the awareness on intellectual property rights. Dear students, if you just compare the patent filing with China and any other developed country, then you can see that the patent filing in India is very, very less as compared to China. In China, it's about 50 lakhs patent application per year, but in India, it's only 50,000. It's about not 50 lakhs, 10 lakhs. So it's about 20 times lesser than the China. If you compare with the USA, which is less populated than India, they are also filing 5 lakhs patent application per year. It's just because we are not much aware about the intellectual property rights, and we are not aware the fact that how we can utilize the intellectual property rights just by protecting them to the benefit of our business, to the benefit of our career. So it's very important to know the importance of intellectual property rights, and also what are the creativity you have which you can convert into intellectual property rights. And most important is that what are the things which is protectable and what are the things which is not protectable. We will cover the things in this session, and how to convert your innovation into proprietary assets, and how you can utilize the intellectual property information which is already filed in the patent office, how you can utilize that and to use those information in your field and to come out with a new idea, new product, new process. And finally, how you can use by protecting your ideas and using your ideas in your business and in your creativity to become a job giver than the job seeker. The overview of the session is, first I'll introduce about intellectual property rights, and then what is the significance and importance of intellectual property rights, what are the different kinds of intellectual property rights, and mainly as this institute belongs to technology, so I'll mainly focus on patent parts, and I'll explain everything from starting, what should be the structure of the patent application, what are the filing fee, what should be the form should be filed, what is the process of examinations. All these things I'll cover in details for the patent section. Other sections I'll describe in shortly. Other intellectual property rights like design trademarks, copyrights, SICLD, geographical indications, and trade secrets. I'll just describe all these intellectual properties in briefly. So before coming to the rights, just we need to understand what is intellectual property rights. All of us know about that, but we know the intellectual property right in a different way. For example, we all of us know that a particular book which is famous and published by particular publications cannot be published by any other publications, or a beautiful car design cannot be simply copied by any other automobile company, or any movie which is already in any OTT platform. For example, Puspa movie is available in Amazon platform, but it's not available in any other OTT platform. Why it is so? It is mainly because the creator of all these things have the rights over their work. So all these works are
Sorry to interrupt you, sir.
okay.
Just a second. Sir, can you just give the privileges to either Dr. Srinivas or myself so that we can manage the
Yes, sir, yes, sir.
environment? Yeah.
I'll
So
just
that
make
there
you.
will not be any disturbance.
Yes, sir. I'll just make you co-host.
Ah, co-host. Yes. Dr. Raghu to
Sir,
please.
Dr. MMS Srinivas, sir.
Yes, sir. Yeah.
Oh, sir. Okay, sir. So, okay, sir. I have making co-host, sir.
Yes, sir. Yeah.
That's fine, sir.
Sir. Fine, sir. Fine, sir. We will take care of it. We will take care of the proceedings, sir. Yeah. Please continue, sir. Sorry for the disturbance. And there is something that is coming, blocking the screen, in fact.
Okay, now it's fine, sir, because I'll have to see this one videos list.
Okay.
So
Okay,
this
okay, sir.
thing will be there.
It's fine, sir. It's fine, sir. Thank you. Thank you.
Okay, thank you.
Please
So,
carry on, sir. Thank you. Thank
okay, so we know that no one can simply copy a design of a car or a book written by someone, or for that matter, any kind which is protected by someone. So we know that a book is written by an author is a property of the author, and nobody can simply take that or can simply copy that and can sell the market without the consent of the author. In a similar way, nobody can use any company's trademark for their business without the consent of the trademark holder. So all these things we know about intellectual property rights, but in a different way. We know that these things cannot be copied because it belongs to someone, and the original creator is the owner of these properties. And in the same way, the way if we buy, nobody can use that without your permissions. Like the same way, if you write a book, if you like, create a painting, or if you make a device, or you come out with a new process for manufacturing any product, that cannot be simply copied by anyone without your consent. But for that, you need to protect that. If we'll divide the intellectual property in two different sections, then one comes in the tangible property, other can comes in the intangible property. For example, a company, if if we see the tangible property of any company, then tangible property includes like land, any vehicle, any manufacturing device, manufacturing machine, telephones, AC, everything. These things comes under the tangible property. But if we see the intangible property of any companies, then it includes the brand value of company, the patents taken by the company, or copyright of its manual that comes under the intangible property. So most of the companies are not interested in intangible property because they know that in this competitive market, we cannot compete with our competitor without the help of intangible property. But to create the intangible property, what you need for that, you'll have to do the research and development works, R&D works. You'll have to apply your minds to solve the problems which is existing in the device, or you'll have to come out with a new product. And for that, you need to put your time. You need to spend your time. Then you can come to a property which is called intangible property or intellectual property. So basically, a property which is created by a human intellect is called intangible property. If you see, whatever plan you have in future, you can use your creativity to create intellectual property, and finally you can protect them for your benefit, economic, to get the economic benefit out of that. For example, if someone is interested in painting, he can go for trademark. Sorry, he can go for a copyright. If he's planning for a startup, he can go for a trademark for his startup. If he's trying to or planning for writing a novel, he can go for a copyrights. If he's planning to come out with a new device which is technologically advanced, he can go for the patent. If he is planning to come with a new website or new applications, mobile applications, he can go for a copyrights. So in whatever fields you want to go, you can use your creativity to create intellectual property rights and to protect them to get the maximum economic benefit out of your creativity. So what is the innovation cycles? How are intellectual properties being created? So for that, first thing comes imagination. First, we'll have to see what is not there. It comes from need. Then that needs you help. That needs you help you to imagine about that, how to get that. Your imaginations will lead to creativity, and your creativity will finally leads to the innovations, and after innovations you can come to the actual product, actual process of intellectual property rights. For example, in this COVID period, everybody was uh, was feeling the necessity of the COVID vaccines. So the persons, those who were in that field, those who were doing research and development in that field, he felt that this is needed and we can do that. And with their imaginations, he come out with the way how to create or to make the vaccines. And after going through the research and development works, they come actually to the products. So all the inventions comes through all these cycles. First it starts from the imaginations, then creativity, then innovations, then finally you can go for the rights, means entrepreneurship. I'll just give a simple example how an invention comes. Just wait a minute. Sorry for the disturbance, sir. Just I'll give you an example of application is filed in Patent Office Chennai, and this application was filed just 10 years old boy, and he filed the application for a device that if when his hand got fractured, he need to hold his hand with the help of sling, which was actually supported by his neck, and he need to do that for a longer period of the time, about 16 years, 16 hours. So he felt pain in his neck. So he thought, why can't we come? Why can't we have some different way to hold my hand so that my neck pain, so that I don't feel any neck pain, and at the same time, the purpose for the holding of hand should be realized. So he came out with a new kind of belt which is wearable, which can be wearable with his waist, and there is a supporting things which is attached to the belt. With the help of that, a broken hand can be placed over that, and which solves the problem that the hand should be in a fixed manner so that the plaster should not be disturbed. So he came out with the new solutions. Like this way only, we need to understand what is the problem existing or what we need for any, and why what come out with the new product which solves the limitations of any product or problem of any product. Then I'll just see what are the significance and importance of the intellectual property rights. So first of all, when you get a right of your intellectual property, then it ensures that nobody will use, nobody can copy, nobody can sell, nobody can make, and even nobody can import that product or any intellectual property right for which you have the rights. Nobody can even import that product or process or even other intellectual properties without your consent, and you are the sole owner to use, sell, or even import, and to get the maximum benefit, economic benefit out of that. And at the same time, it excludes others by copying, selling, making. Doing that, you can utilize your inventions in a commercial manner and you can get economic benefit. Just if I'll just you'll see the this one pie chart for the tangible and intangible properties for the big companies, or even includes the all companies all over the world. It's data taken from the WIPO, World Intellectual Property Organizations. It shows that when the economy was based on the manufacturing, then the companies were more interested in tangible assets, means they were more interested in having big manufacturing machines, in the big campus, big manpowers and all. And they include about 80% assets they had about tangible assets. 80% assets they had tangible assets. But now when the economy is driven through the technology, they are more interested in intangible assets, and now they have about 80% assets are intangible assets. This shows that how it is important for any kind of business. This is the index of Global Innovation Index. India is at 46th position in 2021, and we'll see the ranking of developed country. You'll find almost all the countries which in 1 to 10th rank, all these countries are developed countries. It shows how the scientific temperament of any country is important for the economic development of any country. It also includes all these things, patent rights. This will show you that how intellectual property rights or rights given to the honor of the creator improves the lives of the society, or also it helps the inventor. Just these are the size of the computers in the different years, and we'll see in now in 2022 the size of the computer is so compact and that is more powerful, that is more effective. Why how it can be happened? It happened just because that the person, those who worked in the field of the computer, the inventor, they got the protection of their rights, and that helped them to get the economic benefits. And after getting the economic benefits, they were more interested to apply the economic benefits, to use the economic benefits in their fields, and to come out with a new advanced product. So the rights help in a very positive manners for the development of any device, for the development of any compact device or highly advanced device, and indirectly that helps to the society to get the desired product as per the requirement, because the rights are given to the inventor, so they enjoy the economic benefits and they get motivated of because of that, and they do more and more research in their field to come out with the new technology. This this was taken from the Hindu newspaper, and all of us know that the Covaxin is produced by the Bharat Biotech, and the research were done by the ICMR, Indian Council of Medical Research. For doing that, the council has spent around 35 crores, and till January 2022, he got about 171 crore as a royalty. So this shows that rights how helps the researchers, how helps the research institute to do more and more research in their fields. Otherwise, why anybody would work if you will not get any economic benefit after coming with the new product and process? Because if they will not have the rights and the government does not give the exclusive rights, then anybody can just copy that product by the reverse engineering, and they come out with a new product, and they can sell the same product in a different brand name, and they will get the economic benefits. What is the utilization and commercialization of the patent rights or other intellectual property rights? You can use for yourself, you can give license, or you can assign to other company to use your technology, and for that you will get the economic benefits. You can earn through merchandise and franchise also. If you see the common person, these intellectual property rights is a matter of rights, and they use these intellectual property rights in academic and their academic careers. But for the businessman, they see all these intellectual property rights for the economic benefit only. They use these intellectual property rights to commercialize their product, to make the brand value of their company, and through that they earn more and more from that, and again he invest in the research and development so that they can come out with a new advanced product. These are the different sections of intellectual property rights. First one is patents, then design, trademark, copyright, semiconductor, integrated circuit layout designs, geographical indications, protection of undisclosed information or trade secret. First of all, I'll start with the patents. This section I'll explain in the details, so that if you have any plan in your mind, if you are planning to invent something or to come out with a new process, you can just understand what are the things required before filing the applications, and after the filing of the application, what are the process need to be followed. So first of all, we need to understand for what we get the patent. The patents is given for the product and process. It is not given for the writing a novel, or for a painting, or for a brand value, or for any logo, or for a design. It's not given for that, but it's only given for the product and process. If you come out with a new product which is already existing, but that is technically advanced, for that you get a product, for that you can get a patent. And also for a process, even a product is there, but if you coming to the same product but with the new process which is economical, or something which is easy, or that is new process, for that also you'll get a patent. So basically you get a patent for a product and process for the 20 years, and within the territorial rights. So patent prevent the third parties without authorization from making, using, offering for sale, selling, or importing any product covered by a patent. If a patent is for a process, then from the using the process or a product obtained by that process for the above action. So even if you have uh, taken the patent of your process, then nobody can Sir, screen is visual, sir. Sir, screen is visual. Sir, am I audible or not? Please respond soon.
Sir, you are
Sir,
audible and the screen is
sir, I
also
have
visible,
video
sir.
call, sir.
Yes, sir. Yes, sir. Thank you very much, sir.
Fine.
Yeah.
Okay. So
It is
we,
not in presentation mode, sir. It is not in presentation mode.
yes, sir.
Can you go to slideshow, sir?
Okay,
It is
okay, sir.
not. Yeah.
So
Now
dear
it's fine.
students,
Yeah.
we see that patents are granted for the product and process. We will see what are the criteria. But before that, I just want to tell you that these rights are territorial in nature. It means if you get the rights in India, you will have the rights to make, use, or sell your product or your process in India only, and it doesn't cover your rights in other countries. So if you want to get the rights of your patents in other countries also, then you will have file a corresponding patent application in other countries also, because these rights are governed through a patent act and all the countries having the different patent acts. For example, in India, the software is not patentable. Software doesn't comes under the patent, but in USA it comes under the patent. They like the other ways, some sections in the patent act in under section 3, which includes what are the things which is not patentable, and many the things which is not patentable in India, the same is patentable in other countries. And one more thing to know very clearly that there is nothing called international patent. However, you can file your patent in a different country uh, 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 at a time with the help of PCT. You can file applications with the different country, means you can file international applications, but you cannot get the international patent. For getting the patent, you need to apply in the different countries separately. Just, just see this. What are the criteria for granting a patent? So first is that novel. Second step is inventive steps. Third is capable of industrial applications. Novel, it means the product or your process which you are claiming for the patent, that should be new. It means that should be not known to anyone before the filing date of your applications, and that also that should not described in any single documents which is published before the filing date of your applications. For example, if you filed your application today, then whatever you are claiming in your patent application, that should be not described in a single publication or single documents. All the features should be not disclosed there before the filing date of your applications. Second is that your application, your claim should be, or your product or process should be technically advanced. It means you doesn't need to come out with a new product which doesn't exist. But even if you come out with a product which is technically advanced of the existing product, that qualifies the criteria of the inventive steps. So there is a myth that, and many students, those many friends, those who are in the research, and they think that I need to come with a new product which is not known to anybody for getting a patent. But it's not like that. You don't need to invent. You need to innovate. So whatever the device, it is already there. If you come out with a new device, with the help of your idea, with the help of your research and development, and that solves the limitation of the existing device, that qualifies the criteria of inventive steps. And simple means it should not be obvious. It means nobody can just simply understand your invention. Okay, so if you are claiming that this is my invention, it means that requires your original idea to come out with that product. Okay, so that should not be obvious. For example, if somebody make a umbrella with torch light, then it is very simple. Anybody can think about that. So these two devices working separately, and anybody can just attach that. So it's not about that I made an umbrella with the light. So it's not comes under the inventive steps, and that cannot be considered as a technically advanced. But for example, somebody comes with an umbrella having some solar kind of things which is already embedded in the with the umbrella, and if using that things, that solar energy, and if they are with the help of that they are coming with the new kind of light, that can be patentable because that requires the advanced knowledge, that requires your new idea to do that. Okay, and other criteria is capable of industrial applications. It simply means whatever you are claiming, that can be manufactured by a manufacturing process. Now I'll just give you a simple example which helps you to just know that what is a novel, what is inventive steps. Okay, this is very simple example I have taken. For example, some applicant has claimed that I made a device. I made the pen and eraser as a single unit. Okay, so he claiming that this is new and this is my original idea, so I should get the patent for this. He claimed in his patent applications. Once he claimed, then patent office will examine whether this is new or not. So whether it is new or not, nobody can say without citing the documents. So then patent office will search the documents related to these inventions, and if he comes with the two different documents, that one disclosing the pencil and other disclosing the eraser, then he will based on these documents he can say that yes, this invention is novel, because no application, only these two, if you just imagine that he got only two publications before the filing date of his applications, only one is describing the pencil, other is eraser, then based on these two he will decide that yes, this application is novel. But whether it is inventive or not, for that he will just see the why the applicant has invented this. He invented this because a user of the pencil and eraser, we usually need this at the same time. When we use pencil, we need eraser also. So he just wanted to solve that problem that the user can use the eraser also and pencil also, and in both things as a single unit. Then examiner of the patterns and design will just understand that whether it is solving the problem or not. So he just see they will go through the description and he will come out with that. He has not mentioned any solution that how to fix the eraser. He just simply use some quick solution or some addition material by just fixing that eraser. Then what will happen when they will use the eraser, user will use the eraser, it will come out because it is not fixed in a proper manner. So this applications does not qualify the inventive steps. Now come to the second example. If other applicant has filed applications with this kind of pencil and he's claiming the same, that I am making a article having the pencil and eraser as a single unit, then examiner will just with the help of these two documents only, which is cited, which I have already find that one is describing pencil and other is eraser. Then based on that, examiner can decide that whether it is inventive or not, and he will go through the description and he will come with the we will come to know that he used a mechanical process to fix the eraser, and that actually helps that it will not simply come out while using the eraser. So this involves the technically advanced product, and this is technically advanced product and which solves the existing problem. No, so this was the examples for the inventive steps and novelty. Now I'll just quickly see what are the different products. Examples of the patent example. First one is a cap-like structure which protects the face of the baby. So we'll just see that whether we need some specific kind of technology to invent this. I think no. We need to curious about solving a problem, then we can come out with this kind of product. So some inventions can be very simple, which can be invented even by an illiterate person also, because if he'll have the idea, he can come out with a new solution. But some inventions are very technologically advanced and that cannot be invented without the research and development. For example, other is a band which used as a projector, and next one is a mobile a device which helps to transactions from the mobile, then drones, then some foldable clips, and this LED wicket with the LED lights, and very famous shoe used by the Michael Jackson, which helped him to bend up to 45 degrees. However, a normal person cannot bend more than 20 degrees, but he invented a shoe which helped him to bend about 45 degrees, and because of that his moves were very famous, and he used his inventions in his profession to become more famous in his areas. So he was not only a very good dancer, very good performer, but he was an inventor also. Just I'll talk about this invention, this cricket wicket. This invention was invented by a player who was a cricketer in England. He came out with the idea when he bought a toy for his son, and there was a light. So he think that why can't we use this technology to improve the decision of the umpires? What happens? Sometimes this bells doesn't come down, and however the balls touch the bells and it doesn't comes. In that situations, nobody knows about that whether the balls hits the bells or not. But with the help of this technology, even the fraction of seconds, means one by thousands of the seconds, there will be break of this stumps and bells, if there will be disconnection between the bells and the stumps, then it will blinks. So that will actually help right decisions, very economical hepatitis vaccine, which were in others company it was around 32 rupees, $32 per dose, but the vaccine which was invented in India, which cost only $1 per dose. Jaipur food is also very famous. It's very affordable. So we have discussed that how an inventor gets the benefit when he invents something with the help of exclusive right. Then what is the benefit of society? The society gets benefits in the different way. Now it is fine, sir.
Yes, sir. Fine, sir.
Okay, thank you, sir.
Yeah.
Now we'll see what is the benefit to the society by inventing. Inventor gets the benefit with because he gets the exclusive rights for the certain period of the time. But then what is what his inventions when he gives the details, and when it comes to the patent office, after the certain period of the times, that is 18 months, it patent office published all the application which is filed, and then it becomes public to everyone. It becomes public, so anybody can access those documents and they can go through the documents which is of their field, and they can go through the advanced they can know the what are the things advanced happening in their fields, and they can get some idea out of that, and they can use that idea in their work. So it's one benefit is that. Other is transferring into public property after expiry of the patents. For example, if somebody is filed today, then after the 20 years, if he gets the patent, then their rights will be over. So anybody can use that same technology. They can produce the same product for their use, and even for they can use for the businesses also. Some inventions are not patentable. We'll just see quickly this mentioned in under section 3 of the Patent Act 1970. Frivolous invention is not patentable. For example, inventions which is not having any scientific support. For example, if somebody comes with a new product like and he's claiming that with the wearing of this product, the person can become happy or person can become prosperous, then this kind of inventions cannot be patentable. Or some inventions which is which challenging the Newton's first law, second law, which is contrary to the scientific laws, those kind of inventions cannot be patentable. Contrary to law or mortality cannot be patentable. Mere discovery of new form of the new device substances, that is also not patentable. Mere admixturing resulting only in the aggregation, just mixing two things and coming with a new product, that is also not patentable. Mere arrangement or rearrangement of the known devices, which is not patentable. Method of agriculture and horticulture is not patentable. And method of treatment of human being is also not patentable. However, the product which is used in the treatment, for example, if some doctors come out with a new device which helps in the treatment of the human being, that comes under the patent. But the way of treatment cannot be patentable. Literary and dramatic musical works are not doesn't comes under the patent, and it comes under the copyright. The presentation of information, for example, the way I am presenting, this cannot be patentable. Or topography of any integrated circuit is also not patentable. So be careful about publishing aspect before filing the applications. What happens? We think that after the completion of my research work, we'll file a patent. And after a certain process, once we'll come out with all the steps of the process, then we'll file a patent. But we should not do like that, because patents is about first come, first serve. So whoever will file the first, their priority will be saved. Means if you are filing applications which are known to you before 1 year, but if you are filing today, then in between 1 year, if anybody files the subject matter which you are filing today, then your applications will be rejected based on the basis that your application doesn't have novelty. Your claims is not novel. So filing date is very, very important. So we should not wait to come to finish our research work and then to file the patent applications. But whenever you get an idea of your product and you think that this is very novel and this is your original idea, and after certain period of times, for example, within 1 year, you'll able to complete your product or you're able to complete your research work, then you should file your application as early as possible, because it will protect your priority date. It means any publications after that will not harm your applications in the view of granting a patent. So before completing your product or research work, you can file your applications. But suppose you have disclosed your idea or you have presented your work in some webinar or somewhere, and or you have published your work in some journals, then also you have the right to file your application within 12 years. There is a grace period given for India only, Indian applicant only. You have the 12 years to file your applications without losing your priority dates. Then what should be the structure of the patent application? We'll see. We'll have to mention your title. Then what are the prior arts, means what are the work had been done in the field which you have filing for the patent. What are the drawbacks in the prior arts? Efforts of solution to the drawbacks, means what you are doing to come out with a new product which solves the drawbacks of the existing product. Then summary of the inventions, then details description of the inventions, then detailed description with reference to the drawings if you have mentioned some drawings, then few examples, then claims, then abstract, and then drawings. All these things, applications should be written in this fashion only. But the most important in the application, your application, is claim. It's a techno-legal statement, and you get patents or you get a right of your product or your process only for what you have mentioned in the claims, and you don't get the patents of all the description part, but you get the patents only for the things, only for the features of your product which you have mentioned in the claims. So it should be written in such a manner that it, it should protect your rights, it should protect your idea. So claims should not be written in a very uh, uh, compact, or it should not be written in a very elaborated manner. If you claim your product in a very elaborated manner, then definitely that will be available in any prior arts. And if you write your claims in a very narrow, then what will happen, even after getting the patents, will have the very little scope to utilize your patent in your product to get the maximum benefit, economic benefit from that. So you should be very focused to write claims. It should not be very narrow, and at the same time it should not be very mentioned in a very described manner. Then we'll see what is the process. What are the forms required? Form 1, Form 2, Form 3, Form 5 and Form 18 are required. All these forms are available in Government of India's website, ipindia.gov.in. All the process are also mentioned there, and all the forms you can download from there. So Form 1 basically includes the details of the applicants. Form 2 includes the description parts of the inventions. Form 3 includes the details of the foreign filing of the similar applications. Form 5 includes details of foreign filing of the similar applications, the inventorships. And Form 18 is for the request of examinations. Means once you have filed your applications, you need to file a separate form for the examinations, that is Form 18. Without that, your application will be not examined. So for the examination, you need to file Form 18. This is the fee for the patent applications. If you are natural persons or a startup or a small entity or educational, this is the fee for the patent applications. The total cost around 5,600. It includes the examination fee also. And other than the natural persons, for a company, it's about 28,000. You can file your applications physically to your to the patent office. Otherwise, you can file your applications through e-portal also. This is the page of the comprehensive e-filing portal. I'll just quickly explain different kinds of applications. The applications which is not claiming any priority date, that comes under the ordinary applications. For example, if you are applying in India first time and you are not claiming any priority date, that will be considered as a ordinary applications. For the convention applications means if you have already filed in India and if you want to file, if you have already filed in India and if you want to file your corresponding application in different countries, then we'll have the 12 months to claim your priority, and you can file with the other countries. And if you are filing your application through PCT, then you will have the 30 months to file any other country without affecting your priority date. So these are the applications. For generally, if you are filing in India, it comes under the ordinary applications. If you are filing in the different countries, then but with the limited countries only, that will comes under the convention. But if you want to file in many countries, like 20 countries, 15 countries, then you should go through the PCT, and you can file your applications by going through the PCT at a single time, just by with the single applications applying through PCT. And we'll have the in India it is 31 months. If somebody filing others from India, outside from the India, they will have the 31 months to file in India. But when we will have the 31 months to, it's 30 months only. Then once you filed your applications, then it comes to the examination sections. After the examinations, formal and technical examinations, first examination report generated and it sent to the applicant. Applicant goes through all the objections and they reply to those objections within 6 months. And after that, if controller finds everything in a order, then he grants the patent. And if he thinks that some objections are still not met and some objections need some clarifications, he asks the applicant for the hearing, to come for the hearing, and their applicant can give their applicant can give his explanation about the objections, and based on that, the applicant assistant controller or controller of the patents and design, they grant the application or they refuse the applications. There are some timelines. Provisional application to complete application, it takes 12 months. For the examinations, you need to file Form 18 within 48 months. To reply the IPR, it's 6 months. For the expedited examinations, facilities are there. If you belongs to any one of these category, if you are a startup or small entity or applicant is female, if there is a joint application, then even one applicant is female, then they are eligible for the request of expedited examinations. And once you file expedited examination, it takes maximum 1 or 2 months to get your application examined. So I've covered the first part, patents. So if you have any questions, please ask the chat box. Otherwise, you can unmute yourself and you can ask your questions till patent section. You can ask your question. Then I'll quickly go for other section.
Sir, are we open for questionnaire, sir?
Yes, sir. Yes, sir. For patent section only, sir. Other section I'll cover in just 30 minutes. Next 30 minutes.
So the one question from some of my faculty members over here.
Okay.
What is the difference between this copyright and patent? Is it possible to deal with copyright and patent, sir? Copyright.
Okay, sir. Sir, generally copyrights are given for like a dramatic works, literary works, or cinematographic works, but patents is only given for the product and process. Product and process. It means, sir, we'll have to come out with a new product. For example, like if somebody is coming out with a new kind of solar system, new kind of mobile phones, advanced mobile phones, or camera, anything, new kind of chair or camera, or somebody comes through any process. For example, somebody is making some device, but they are coming with the same device but with the new process, that comes under the patents. But for the copyrights, this is the different sections, sir, that only ensures about the literary works, dramatic works, cinematographic works, painting, sculptures, like this only.
Yes, sir. Thank you, sir. And one more question, sir.
Yes.
So, what is this difference between patent publication and patent granting?
Patent communications and patent grant.
Patent published and patent granted. Patent published
Yes.
and patent granted.
Okay, sir. Sir, one thing is that when applicant file application, sir, within 48 months, or within 18 months, or you can say after 18 months, just after 18 months, it gets published. Earlier, it was published through physical copy also, but nowadays it is generally published weekly basis. It is published in the website of CGPDTM, Controller General of Patents and Designs and Trademarks. So it is published. So application published. This is application published. If you are asking about the patent publication, it means when it is granted, then it will be published. So all these data you can find in IP India website set, what are the patents granted and what is published. So once it is granted, sir, then it is published in the website of IP India. So if you are asking about the application publication, then it's different thing. Application publication means whoever will file the patent application, it will be published after 18 months. But patent publication, it means once the patent granted for any applications, then it is published in the IP India websites for the public. Am I clear to you, sir?
Yes, sir. Pretty much clear, sir. And one last question, sir.
Yes.
Sir, after filing, I mean, after application filing or communication, so usually what is the minimum time for going for this examination, sir? And
Yes,
is
sir.
there any possibility of going for a rapid examination process or quicker
Yes, sir.
examination process?
Yes, sir. For that, sir, there is expedited examinations. So I have sir, this one expedited examination just explained, sir. But for that, it is only this facility is given for these applicant only. If the applicant is a startup, suppose they have the sub applicant is coming with a startup and they have registered to the government of India as a startup, then he will be eligible for filing expedited examinations, or even a small eligible for filing expedited examinations. For applicant is female. So if the applicant belongs to this category, they can file for the expedited examination, and their application will be examined within 1 month, sir. Within 1 month or 2 months maximum. But this facility is given only for application will be examined within 1 month, sir. Within 1 month or 2 months maximum. But this is applicant. This is not for all, sir. Sir,
Thank
any
you.
questions from participants, sir, from a student?
Yes, sir. Participants, sir. I'm just reading them, sir.
Okay, sir, then fine. If some participants will ask the questions, then it will be fine, sir.
Yes, sir. 1 second, sir.
Okay.
Sir, one more question. Can we take one more question, sir?
Yes, sir. We
Yeah.
have sufficient time.
Yes, sir. Sir, it is like in our college, while we are submitting a patent application,
Yes,
usually what we do is we collaborate with students, or student would be collaborating with the faculty members, and jointly we are submitting application for patent. In that case, the college management is taking care of all the expenditures if there is anything that is incurred during the process.
okay,
And
sir.
what we are doing on the other side is we are quoting our college name as the owner,
Okay, sir.
and the inventors are the candidates who are actually physically filing the application, whose names are mentioned in it.
Okay, sir.
So, what exactly difference between being an owner and how it makes a difference with respect to the inventors? And in future, what if we leave this college or the functional, if this company,
Yes, sir.
will the patent still be remaining with the inventors or the owner?
Yes, sir. First of all, sir, I'd like to tell that in Form 1, it includes everything, who is the applicant, who is the inventor. And if the applicant and inventor is different, then they will have to give the assignment. They'll have to give the rights. But sir, a patent is granted to the applicant only, not to the inventor. So patent will be granted in the name of applicant only. So whoever name is mentioned in the Form 1 as applicants, the patent will be granted to applicant only, and the name will be mentioned in the patent grant of the patent. The certificates, in the certificates also, the name applicant name will be mentioned in the certificate. So, sir, once you leave the or you are working in there, sir, once you have given the rights, because the applicant and inventor is different, then you are giving the rights to the applicant to use your inventions in whatever the manner they want to use. So once you have given the rights to the applicant, then they then will have no rights to your invention or your product or your processor.
Thank you, sir. This is a question from actually some of my students.
Okay, sir.
He
So this one is clear
has,
to you, sir. Last one. Last one, last question. I explained it clearly or not, sir?
yes, sir, it is clear, sir.
Okay, okay, sir.
They are convinced actually. They got the necessary information that is required actually.
Okay, sir.
They are budding entrepreneurs from this college studying third year and the second year of
Okay.
engineering. So they have started their own startup, which are yet to be registered, of course.
Sir, your
But
voice is not coming clear, sir. It's like
okay,
broken voice
am
I'm
I
getting.
clear, sir? Now am I clear? Hello.
No, no, sir. Okay, sir, please come again.
Yeah. Sir, am I audible now?
Yes, no, sir, no, it's
Yeah.
fine.
This is a question actually. The last question was from some of my students who are budding entrepreneurs from second and third years, sir. So they have
Okay,
started a small company in the incubation center of my college, and now they are heading to file patents through this college, and they just interested to know about what exactly being an ownership and what exactly being an inventor and all these things. So now your question, your response and your answer, whatever that you have provided to us is very much convincing, and they're satisfied, sir. Thank you.
sir. Yes, sir. In that case, also, sir, he can ask the company that he can make the co-applicant also. There can be more than one applicant. So, and otherwise, sir, it's between only inventor and applicant only, sir. In whatever they want to deal with, because most of the companies are doing research to get the economic benefits, and applicant knows uh, that he pays the salary, or in the other forms, that he pays money to the inventor to doing that. So they generally want to get the full right of the invention, but the inventor thinks that I should have also some right over that. He can just they will have to just make some agreement between this. They will have to just make some inventor and applicant only. After the commercialization, how they will share the benefit. So it's just the commercialization, how they will share the benefit. So it's just a matter of applicant and inventor. Okay, sir?
Yeah, yes, sir. Thank you, sir. And there is a small request from our side.
Inventor.
Uh,
Okay, sir?
at the end
Yes, sir.
of your lecture, or maybe in your lecture itself, try to throw some light on the activities of Kapila scheme, sir, and how this scheme will be beneficial to the students and faculty members of this college, and how do we have to proceed ahead with the scheme, the procedure.
Sir, actually, I've gone through this scheme, and this scheme actually, sir, not directly helping to a particular student, sir, but the scheme helping that. Suppose example, if you are a member of the Kapila scheme in your college, then they are giving this one financial benefit up to 10 applications. They are waiving off the fee. For example, they are applying for up to 10 claims and 30 pages. Then total cost of their applications will be around 5,600. So up to 10 applications, they will, I think, reimburse the money after the applications. So I think, sir, they are providing only financial benefits to the institutions and faculty or students, but they are not giving any other assistance like how they commercialize or other things. So they are giving only financial benefits, sir. And for that also for filing the application.
So, you mean that initially the expenditure has to be done, but later on it will be reimbursed, right, sir?
Yes, sir. Up to
Right.
10 applications. But the
Right.
amounts are about total amount will be 5,000, 56,000 around.
Right. So,
Okay, sir.
10
Can
applications
you?
per year?
Yes, sir.
10 applications per year, you mean to say, sir?
Yes, sir. I think so.
Okay. Okay, sir. Thank you, sir.
But can you proceed to other different other sections, sir?
Yes,
Design.
sir. Yes, sir. Please. Thank you, sir.
Till now, we have discussed about how a advanced product or new process can be comes under the protections. But even a product includes only the outer set of the product, that also comes under the protection, which comes under the Industrial Design Act, the Design Act 2000 and Design Rules 2001, and it protects only the outer shape, or simply the it only protects the shape of any bottle or any product, because we know that when we buy a product, we don't just go for the quality or efficiency of product, but we also go for the looks of the product. It comes, it looks, it appears, good or in a different or new or stylish, then we go for that product. So these kind of features of any product, which can be solely that can be judged solely by the eye, that comes under the Design Act, and it includes the feature of shapes, configurations, pattern, ornament or composition of lines or colors, and it can be 2D or 3D. So anything which actually comprises the appearance of any products, that comes under the Design Act. So just see the few examples. It may be the design of any bottles, it may be design of cars, design of sofa, watches, even design of clothes. All these things comes under the Design Act. Or it can be protected. If you have the new design of any product, you can protect your design by applying to the patent office. For the patent, examination is done at the all different locations like Mumbai, Delhi, Chennai, and Kolkata. But for the design applications, it is only examined at the patent office, Kolkata. So if you are filing online, then it's fine, you can file. But if you are filing through the physical filing, then you can file to the different locations, which is situated at Delhi, different patent office, Delhi, Mumbai, Chennai, and Kolkata, and that will actually after digitizations, that will actually send to the patent office, Kolkata, for the examination purpose. But if you're and for that you need to make a demand draft in a favor of patent office, Kolkata only. It means controller of designs, patent payable at Kolkata. If you have registered design, you should mention registered or RAGD or RD, so that it may deter potential infringer and it will help you to take the legal actions those who copy your design. The terms of design is for 10 years, which can be extendable by the 5 years, but you need to apply for the renewals within 10 years. I'll go to the different section, trademarks. These are the famous trademark. We know Adidas, Google's, McDonald's, Coca-Cola. All these are very famous trademark. All of us know about that. So what is actually trademark? It is basically a sign that is used to distinguish the goods or services offered by one undertaking from those offered by another undertaking. What can be the trademark? It may be a sign, it may be a words, it may be a letters, it may be numbers, or combination of all these things. Even packaging or sound of any products comes under the trademark. For example, the ringtone of Apple is a trademark of the Apple. Or packaging, if you order the foods from the online platform, then you see that some different startups, they provide their products in a different, very interesting packaging. So that is also trademarks. So trademark doesn't only sign words or letters, but even packaging or sound comes under the trademark. What should be the criteria? Should be the trademark. If you are planning for a startup and if you want to take a trademark, then what should be the criteria? Once you apply your trademark, then what is the criteria for examination that whether you will get the trademark or not? The first one is that your trademark should be distinctive. It means it should be different from others, and At the same time, it should not be descriptive. It means your trademark should not explain your business. For example, a company which is dealing with the fruits or selling fruits, and he wants to get a trademark of apple, and he applies to the patent office, intellectual property office. He won't get the trademark of apple because this trademark apple describes his business, so that cannot be given as a trademark to the applicant, those who are dealing with the things which describes the trademark. But we know that the Apple trademark is given to the electronic company. So the first thing is that it should not be descriptive, and other thing is it not should be distinctive. And second criteria is that it not should be deceptive. It should be distinctive, but it not should be descriptive. And second is that it should not be deceptive, means a company who is not dealing with the real leather and he asks for the trademark real leather, he cannot be given the trademark of the real leathers. The trademark ensures the quality of the goods and services, and it also helps to make the goodwill and brand of the company among the public. In India, trademark registration is not mandatory, but you can have your own trademark for your locality. Without registering the trademark, you can use your trademark. But if you want to take your business throughout the country, then you need to register your trademark, because if you will not take the trademark, and if your company becomes famous in your locality, and if others person who is from the different geographical regions, for example, if somebody is geographical regions having a trademark of his business which is famous in the Chennai, and he is not registered his trademark, then somebody can use your trademark in the different locations, and you cannot stop him, because once you will stop him and you go to the court, then court will ask you to prove that how it influence or how it impact your business. Then you cannot able to explain how your business is getting impacted if somebody is using your trademark in the different location which is not known to which is not the area of your business. But once you have registered your trademark, nobody can use within the territory of India. I'll just give you a very brief idea how it is very important. This smiley face was created by a painter, Harvey Ball, in USA in 1961, and for that he drawn this when a company requested him to just draw something so that my employees should get motivated to work. So he just drawn the smiley face, and he got very handsome amount of money for that, but he didn't register that. But after 10 years, a person, he opened a business and he used that smiley face as a trademark for his company, and that company becomes very famous. But the person who is the creator of this trademark or this smiley face cannot claim anything for, he cannot claim anything, cannot claim his trademark because he had not registered their creations as a trademark. And one other example is Facebook. Now the Facebook is working on the metaverse, so they are trying to acquire more and more companies, those who are in there, like WhatsApp is now comes under the Facebook. So they needed a very famous trademark, Meta, because they are trying to make impact in the field of metaverse. So they needed a trademark, Meta, but this trademark was already taken by Meta Financial Company. So they need to pay to get that trademark, Meta, and for that the Facebook paid around 60 million in cash. So just imagine how trademark is important for any company or for any startup. Even Facebook is so famous worldwide, they needed a very strong trademark. So you can see he can go with the Facebook also, but he just wanted to get a trademark which should be suitable for his the new ventures, the metaverse. So he paid very huge amount to get the trademark. I've already explained. You can use your trademark even it is unregistered, but it is valid only for the locality. But if you want to get protection for the whole country, you will have to register your trademark. Without registering it, you can use your trademark by using PN. And when you have registered your trademark, then you can use. And when you have registered your trademark with R, encircle with R. Now I'll just quickly see the copyrights. In every book, in the first 2 pages, we see this trademark. We see this logo. C encircle with C. It includes literary works, artistic works, dramatic works, musical works, sound recording works, cinematographic films, and software programs, website also, and mobile application also. All these things comes under the copyrights. So if you are doing anything new in all these areas, then you are eligible to get a copyright of your original work. So just I'll say quickly the first honor of the creations. For a literary or dramatic work, the author will be the first honor. For the musical work, the music composer will be the honor. For the artistic, other than a photographs, then artist will be the honor. In case of photograph, the person who is taking the photographs will be the first honor for the copyright. For cinematograph, films or sound recording, producers will be the honor. For the literary, dramatic or musical, which is generated through the computers, then the person who causes the work to be created will be the first honor of the works. So it includes the bundle of rights like production right, distribution right, right to create derivative works, right to communications to public, right to public performance. All these rights comes under the copyrights. If you give your rights to other persons, they will enjoy all these rights. Or you get a right, copyrights, then you will have all the rights, all these rights. But we'll have to understand that you cannot get copyright for your ideas. Ideas cannot be protected. But once you use your idea, once you use your creativity into any intellectual property form, then it comes under the protections. For example, if you have a very good idea of making a film, and if you have a story and everything, and if you have told the story to anyone, your friends, and if you find that after a few months, a film made by your friend and they are using your ideas, and then you will come to know that I should claim for the rights of that. Then you will go to the court, then court will not give you the right just because that you haven't expressed your idea before that. You had idea, you just told to someone and they utilize those idea, they express to your idea in a different forms. So your idea cannot be protected, but the expression of idea can be protected under the copyrights. Once you have given the rights of your work, they can use the economic rights. For example, you have written a book and if you have given the permissions to any publication house to sell, to market, to resell, to make a solution of your work, then you have given the economic rights to your publication house, but moral rights will always with you. So whatever the works, derivative works or others works will be done based on your original works, they will have to recognize your name. They will have to mention your names in all the works which you have created originally. Just we'll see quickly for the what are the time period, time protections for the copyrights. For the cinematographic films or sound recordings, it's 60 years from the date of publications. For the broadcast, 25 years. For the performance right, 50 years from the year following the year in which performance is made. We'll see the filing fee. For the literary, dramatic and artistic works, it's 500, and for the others, the different fees are there. I'll just see semiconductor integrated circuit layout design. We have seen the design sections other, but that was only to the products of the outer shape, product of the outer shape, that includes only the outer shape of the products. But for the today's technology, all products are coming with the very compact and the very advanced technology. So they need to come out with a new kind of the circuit design, and that comes under the SICLD. If the product having the transistor and other circuitry elements inseparably formed on or inside a semiconductor or insulating material, that design comes under the SICLD. And it is this application only examines at the Patent Office Delhi, and the registration initially is given for the 10 years, rights is given initially for the 10 years. We'll just see the different forms are there for the different purpose. You can go through the IP India websites and you can download these forms for the applying the applications. For the applications, you need to pay 5,000, and for the different forms, the different fees there. Now I'll see last one, second last, GI, geographical indications. So it is given to a product which having the special reputations or having the special characteristics because of their geographical region. For example, the Tirupati Laddu having a specific taste, having unique taste because of the geographical regions. It is only made in the Tirupati. And if somebody tries to make same kind of laddu from the different locations, then that will be not considered as a Tirupati laddu once the product is given a GI tag. For example, Darjeeling tea is also having the specific taste and aroma because of the locations, because of the climate of the Darjeeling. So it's given a specific recognitions under the GI, like painting or Kolhapuri jaggery or Kolhapuri chappal also, black rice from the northeast. All these things comes under the GI. The benefit of giving GI to this product is that the person, those who are involved in the business of these things or the product which is recognized by the governments, they get more works, their economic condition improves, and also others got afraid that we cannot sell by name of the like Tirupati Laddu by altering by the different by making in a different way. So they will just afraid to use the name of the Tirupati Laddu by selling the laddu which is not prepared there. So it also helps to ensure the quality of the product. Now I'll see the trade secret. Till now, whatever the rights we have discussed, that can only be given to the inventor or the applicant once he will disclose everything about their invention or the product or their design or their trademark. But in the case of trade secret, the companies, they do not disclose their recipe, they do not disclose their formula to anybody, and they enjoy the exclusive rights for the longer periods of time. You can say indefinite period of the time, until and unless the members or the person, those who are involved in those companies, just they disclose their own formula to everybody. So they enjoy the rights for the longer period of time just by not disclosing his inventions, his formula, his recipe to anybody, and it just comes under the agreement of confidentiality, and it is protected under the Contract Act 1872. So for very famous example of Coca-Cola and KFC, Google search algorithm also, they have not disclosed their formula. Nobody knows how the Google search algorithm, how Google search works, though nobody knows about the actual algorithm or the recipe of the Coca-Cola. So all these things comes under the trade secret. We'll just quickly see the validity for patents is given for the 20 years. Design is given for the 10 years but can be extendable by the 5 years. Trademark is given for the indefinite period of time, and GI also given for the indefinite period of time. Copyright is given under the different section for the different period of the time. Except GI, any individual can file for the rights, but for the GI, a group of people can only file. These are the different locations of the different offices, which comes under the different territorial jurisdictions. For the Maharashtra, Gujarat, Madhya Pradesh, Goa, and Chhattisgarh, it comes under the Mumbai office. The states Andhra Pradesh, Kerala, Tamil Nadu, Telangana, all these states comes under the Patent Office Chennai, and Himachal Pradesh, Punjab, Rajasthan, Uttar Pradesh, all these states comes under the New Delhi, and other states like Jharkhand, Bihar, and Northeast, which states comes under the Patent Office Kolkata. So it depends on from where the applicant belongs, and they need to file in their respective patent office for getting the rights. Apart from the patent office, there is a dedicated institute, Rajiv Gandhi National Institute of Intellectual Property and Management, RGNIIPM, which is situated at Nagpur for the training purpose. So if any institutes want a specific training for any intellectual property rights, they can contact to the RGNIIPM Nagpur. These are the buildings of the intellectual property offices at the different locations. Now, if you have any questions, please ask. Otherwise, I'll go for a quiz. I'll just take 10 questions from you.
Yes, sir.
Sir, can we take questions or can we go for quiz, sir?
It's up to you, sir.
Okay, sir.
Good to go with the quiz first.
Okay, sir.
Yeah.
Okay. So just participant can reply through chat box also. I'll just open the chat box. So can participant just tell first one, how can you protect the first one? If you have created, if you have painted a painting, then how can you protect it? Which intellectual property rights you will use to protect your painting? Copyright, okay. For the second one is also copyright. Then third one, it's a mobile. You are seeing just a mobile and laptop with the logo. So how can you just tell me how can you protect the logo of Apple? Trademark, okay. And then how can you protect the shape of the laptop? Anybody can say shape of the laptop. No, shape of the laptop comes under the design. However, the technology which is used in the laptop, that comes under the patent, but shape of the laptops will come under the design. Okay, then fourth one, Bisleri. So if you are trademark, okay. And then anybody can say this one, fifth one, Coca-Cola, it's a trademark. And just I want to give information that even a shape of a bottle comes under the trademark. So shape of a bottle of Coca-Cola is given trademark in Japan. Now please this one, which type of IP protects the painting painted by artist? Okay, already this one is already covered. What protects the, yes please this one, answer this question. What protects the intellectual property created by fashion designer? What protects the intellectual property created by a fashion designer? Okay, thank you, design. Then what protects the advanced disc brake for a bike developed by an inventor? Fourth question, what the, sorry, what protects, third question, what protects the advanced disc brake for bike developed by inventors? Okay, thank you, patents. What does a trademark protects? Logos. How long a patent last? 20 years. Thank you. So many of you are answering. It's very good. Next question. If you are write an original story, what type of intellectual property gives you the right to decide who can make and sell copies of your work? Okay, copyright. Okay, question number 7. Imagine a cricketer set up his own company to sell his own range of clothes. What type of intellectual property can he use to show that the clothes are made by his company? Please go through the questions once again and then please answer. Please go some. No, it won't come under design. Please go through once the question. Okay, someone answer correctly. Okay, so Devi Vardhan is answer correctly. It will come under the trademark. Okay, because imagine a cricketer set up his own company to sell his own range of clothes. What type of intellectual property can he use to show that the clothes are made by his company? So they need to show something that this is made by that company. So yes, so that comes under the trademark only, because just by the uh, just by the trademark only we come to know that this is made by which company. So it will protect it through trademark. Okay, if a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention? Okay, somebody is answering geographical indications. Okay. Okay, so patent is the right answer. Anything which involves the technology that comes under the patent. If you're coming to the product or process with the help of technology which improves the main product, means existing product, that comes under the patents. Okay. Then this is the last question. How much intellectual property is there in a cup of tea? So, for example, you have ordered a cup of tea, then you can tell me how many intellectual properties may be there. To please name the intellectual property sections. trademarks, patents. Okay, so I'll just, can you name the intellectual property rights? T and design of cop. Okay, so design comes under, then T means GI. Okay, Satyam Naidu has answered very correctly. T and this one. Trademark and geographical indication is also right. Trademark, patents and design. Okay, so actually if you consider the design of the glass, it will comes into the design. If you're using a T which is from GI, having the GI, that comes under the geographical indications. And even if suppose there's some something written in the this one, the thread holding this one paper, if some quotations are written or something, that may comes under the copyright also. And even the process through which this glass is made, that may comes under the patents. And one more thing, if this tea is made with the recipe which is known to anybody, then that will comes under the trade secret. So it is having almost all patents, all intellectual property rights. So just now I'll take questions from you. You can ask the questions. This is all from my side. And if you have some specific questions regarding any intellectual property rights, especially from patents, then I can reply you. Otherwise, if you have some doubts in different sections, then I'll forward your questions and they will reply your questions in most possible time, sort of as soon as possible. We'll get a reply. So you can mail your question to this email ID, or for any kind of forms and process, or what are the published patents, what are the granted patents, what are the patents which is refused. If you want to know anything about the patents, design, trademarks, please go to the IPR India websites. And if you have a specific questions, please ask by unmuting yourself. Sir?
Yeah, Satyam Naidu, you can ask the question.
Yes, sir.
Otherwise, we can conclude the session because.
Yes, sir. Sir, only one last question, sir. We
Yes,
will
yes,
be
sir.
concluding it in a minute.
Yes.
Sir, what is Creative Common License?
What is, sir?
Creative Common License.
Creative Common License.
Yeah, yes, sir. See, under copyright and every book, we see that there is a Creative Common License which is open.
We can also be.
Oh, sir, I am actually not clear about this, sir. But I'll let you know. I'll have to ask the person, so those who are from copyrights, I'll ask what is. I'll just take your question, sir. Common. What is the question, sir? Common.
Common.
Please, sir, please come again. I'll just write your question. Okay, sir. Creative Common Copyright License. Okay, sir. Creative Common Copyright License. Okay. Okay, sir. I've noted down your questions. I'll let you know once I get the proper idea about this. I'll let you know, sir. Sir, anything, any more questions, sir? We have very good number of participants. Still, I am not getting questions.
Hello. Yes, sir. Am I audible? Yes, sir. There were so many questions that they have put in, during the second break. During the first session, there were
Okay,
many questions and you have answered many, sir.
okay, sir.
Yes, yes, sir.
So,
Still,
so
if there are
now,
any questions, I will suggest all the participants to direct to the email ID. Thank
okay,
you for sharing the email ID and all the details, sir. Now, I will proceed to the vote of thanks.
okay, sir. Okay, yes, sir.
Yeah. Now, I request Harshini to deliver the vote of thanks.
Thank you, sir. Am I audible, sir?
Yes, sir. Yes.
A jubilant afternoon to one and all. It gives me an immense pleasure to deliver the vote of thanks for this event to all the dignitaries who have attended. First of all, I would like to thank our host and resource person, Sri Ranjit Kumar sir, for conducting this meeting and well explained about the tangible and intangible properties. Well, sir has also explained about the invention cycle, which needs imagination, creativity, innovation, and entrepreneurship. With an example of 10-year-old child named Adi with an innovative thought of appendage around his waist was inspiring. And then about the intellectual property rights, which was very informative and useful. The concept of novelty with a clear demonstrative example of pencil and eraser is well explained. Also, the patent filing mechanism and procedure to be followed is explained clearly. This meeting brought me knowledge on patent life period and expiry, patentable and non-patentable inventions, and on the concept of SICLE and its processing. Last but not least, I would also like to thank our Vice Principal Sir Dr. PSR Chaudhary Sir, staff members, and all the participants for taking the time to be here in the meeting today. Thank you.
Sir, thank you
Thank
very
you,
much.
ma'am.
Thank you, Harshini, and thank you very much, sir, for choosing our college for delivering the lecture as a part of Kapila scheme. We are really happy to have your lecture, and there are many uploads, and you can see a lot of students and faculty members who have participated, which have touched 485, the maximum count that I could see, which is
Yes.
almost equal. Yeah, yes, sir. That was really amazing lecture, sir. So you have given a complete idea on what exactly this is. So we'll be in touch with you, sir, and we'll send all the reports related to this.
Yes, sir. Alternatively, sir, what you can do, because I have been taking many sessions conducted through the Kapila, we get the information of the participants, list of the participants, very late. So, alternately, you can send the participant list to me, my email ID directly, so that we can process for the generation of the certificate, sir, generating certificate. So, you can send the participant list to me also, sir.
Sure, sir. I will share the participants list with you.
Okay, sir.
I would be sharing the Google Form link for attendance. Anyhow, I got the attendance physically from here. But
Okay.
for the sake of information in the form of an Excel, I will definitely share it with you.
Okay, sir. I'm
Yes,
very
yes,
thankful to you, sir, for conducting and showing the interest for the webinar of intellectual property rights. I am very thankful to the management of the Raghu Institute of Technology and also to you, sir, because you've conducted in such a manner that students got uh, uh, came to know that there is a webinar, and I see very good number of participants were there. Still, there is a 280 participants are there, are still present. So you have circulated this information to your to your students, and I hope they will have some idea that how to use their creativity to intellectual property rights. I'm very thankful to all of to you, sir, and to the management of the college.
one more thing, sir, I would like to bring to your notice that whatever the count that you are able to see here is the
Yes,
count
sir.
of number of students who have joined from their mobile.
Okay, sir.
Along with that, we have two projectors in two different laboratories projecting, and all the students are seated there. so that we can save some bandwidth. So in addition to this count, we also have some studies gathered up in the laboratory, and a common projector has been used to project the entire lecture and in the like an auditorium. Yeah,
Okay, sir.
yeah,
Okay, sir.
yeah. And the attendance link is shared in the chat window, chat box. I
Okay, okay,
request all the participants to use the attendance link and submit the Google form.
okay, sir.
Thank you very much, sir. Thank you very much.
Can I conclude the sessions now, sir?
Yeah, yes, sir. Yes, sir. Please. Yes. Thank you,
Thank
sir.
you so much. Thank you.
All the participants are suggested to select Raghu Institute of Technology, not Raghu Engineering College, Raghu Institute of Technology from the list of host institutes.